would say it's simply within the
Well, as a matter of
rights
time,
of the debtor to keep a claim, either to put a claim in the chapter or to keep it out.
Your Honor, as a matter of law, the debtor would be obligated to disclose the claim in the schedule if he knew about it. If he didn't know about it, he can't be required to do what he can't do. But if, in fact, the creditors have a right to these sums, they can go into the bankruptcy court or go into some other court and seek to obtain the proceeds of any recovery. Now, why Marine should be able to make this argument where we claim they're the wrongdoer really basically makes no sense, and that's the clear teaching of the Danziger decision and the Rand decision. Insofar as title is concerned, we believe we always had title. But in any and all events, we didn't know about the claim. There's ample support in the record for a finding that we did not know about the claim, but certainly there's an issue of fact from at least Marine's perspective as to whether we knew about the claim. And as a matter of law, neither special term nor the appellate division could find that we knew about the claim. And we would say that at a minimum, there would have to be a hearing on whether or not we knew about the claim. We found nothing in the record to demonstrate in any respect that we knew about the claim. The only claim against Marine which we knew about are the so-called lockbox causes of action. Those causes of action were pursued during the bankruptcy proceedings. They were pursued with the full knowledge of the bankruptcy court and the creditors committee. And I think that itself indicates to the court that DCA was willing to litigate with Marine when it knew about causes of action against them. And in the 5 or 6 months after the bankruptcy had concluded, we found specific facts, and there was a holding which supported causes of action, and we asserted those causes of action. I've heard my adversary argue that this situation is no different than the corporate officer who, before bankruptcy or during bankruptcy, finds assets, puts them in the ground, and then thereafter seeks to use them for the corporate benefit. That's not what happened here. I think the record makes it clear that we did not know and had no reason to know, and that in a situation like that, there are scores of cases which would indicate that the courts cannot make a finding contrary to us.
You would reject the Stein rule?
Yes, Your Honor. There's absolutely no support in the law except for Stein for this proposition. Stein flatly holds that you don't apply any of the other rules. You apply a rule here which says that since a fellow might have the opportunity not to disclose, we will specifically prohibit him from acting, and that it doesn't make any difference whether he knew or should know, did know, had reason to know. That's just not the law. And it's clear that the language of Stevens, which was in this court, and the language of Lassiter, which was in the Supreme Court, talk about an intentional withholding of claims, and that it's not fair to the creditors.
No other cases like Stein in other circuits?
There is no other case like Stein. There are, if you look for my brief, there are decisions in Hawaii, in Minnesota, I think in New Hampshire, higher state courts, all of which go off on the proposition that in that situation the bankrupt didn't know. There's a case we discussed in our brief called Stipe v. Jefferson, which is I think the highest court in Minnesota in 1934. There's a decision in Kansas in 1976. There are scores of decisions around the country in the highest courts of the states which stand for the proposition that if you didn't know, even when a trustee is appointed, you may pursue the claim. And there's a couple of decisions. There's a decision which permits in New York in Chapter 11 when there's no trustee to proceed. Stein stands out. There's no decision like it.
Mr. Gottlieb, is there any bar to reopening the bankruptcy proceedings?
I would think not, but I can't say I'm an expert on that, Your Honor. There are a couple of other elements I would like to bring to the court's attention here. One of which is the Lapis decision, which is a decision written by Judge Titone several years ago, 3 or 4 years ago, I which stands for the proposition that a fraud cause of action does not arise until the time of discovery, and that if you don't discover the fraud until after the bankruptcy is concluded, you can pursue the claim. That would be another basis for the court to hold that we could at least pursue our fraud claim. There can't, for the same reason I mentioned earlier, the courts were not permitted to hold as a matter of law that we knew about these claims. There was no way that DCA could have known on July 28, 1972, when its loans were not called, that there had been a plan which had been devised months before in order to switch the loan to the classified loan department, and a decision had been made to call the loan. Specifically, after we had representations to the contrary. From DCA's perspective, based upon detailed affidavits, when Marine called the loan, we thought, well, they just changed their mind. It took us until a year and a half after, it took us approximately a year and a half or 2 years finally to get discovery from Marine, which was delayed until after the bankruptcy, to learn that Marine had been acting pursuant to a plan which had been devised before bankruptcy. I should note, maybe it's apparent, there's no claim being made here that we don't state a cause of action. This is simply a summary judgment motion based upon technical positions of standing. The other point I referred to is the lockbox causes of action. Section 70I of the Bankruptcy Act specifically permits a former debtor to pursue claims which have, quote, been dealt with during the bankruptcy proceeding. The lockbox causes of action were dealt with during the bankruptcy proceeding. They're the same causes of action, or some of the same causes of action, which are part of the complaint here. We deal with this issue in detail in our reply brief, but I should just note Marine has argued that they're different causes of action. We quote from one of their prior briefs where they specifically...
Scully, what damages did you suffer here?
Excuse me?
What damages did you suffer here?
They're detailed in our complaint, but they include loss of value of assets, time lost, the additional monies we had to obtain in order to get ourselves out of bankruptcy. There's no claim being made here.
Are these the same claims asserted in the bankruptcy court?
No, Your Honor. That aspect of them is not, but what was asserted in the bankruptcy court and is being asserted here is that Marine breached the lockbox agreement and that there were consequences of that.
I must say, I became somewhat confused by your reply brief, which was longer than your main brief, by the way, with respect to certain of these aspects.
That's primarily because we kept out the last two arguments on the estoppel argument and the other argument. And obviously, Your Honor, the courts below have been focusing on this question of Danziger, and therefore we focused on that as well. I think what I should emphasize most is that Marine really has no right to claim here that these claims belong to other creditors. That's up to the creditors to claim. And for Marine to hang back, this litigation has been in for 11 years now. For them to hang back until 11th, well, I guess they made their motion 3 years before. For them to hang back for 8 years and suddenly say, hey, it's the creditor's claim, I submit is basically unfair. If the creditors want to pursue these claims, they can go into bankruptcy court and do it. If we obtain a recovery here and the creditors say they're entitled to it, they can do it. But I submit Marine can't make that argument.
Thank you very much.
Thank you very much.
Mr. Dickey?
May it please?
What right do you have to make this argument?
I have the right, for one thing, Your Honor, that the Bankruptcy Act lays down precisely the procedures for the vesting and revesting of property of a debtor when there is a Chapter 11 proceeding. I have the right, as anybody else does, to defend myself on the ground that there is no standing, no right, no title and interest in this plaintiff to sue Marine Midland. Now, I may add to that Marine Midland was in fact a creditor, approximately 8% in the proceedings. Marine Midland went along with the confirmation of the arrangement, which it certainly would not have done had it known that it was going to be sued 8 months later by this debtor in possession when it emerged. Now let me answer this fairness point that Mr. Gottlieb closed with. He says we hung back for years and years, and only 3 years ago brought our motion. In fact, in the original answer to the original complaint in this action in 1975, Marine Midland in detail spelled out this defense of lack of standing on the part of this plaintiff on the grounds that we are here discussing today. And that defense, stated in detail, has been repeated in every amended answer following every amended complaint that has been filed by the plaintiff here. There's no unfairness. They could have gone...
What accounts for a lapse of 11 years?
Ask the plaintiff, if the court please, with all respect. We decided that we would allow discovery to carry on. We did not want to be met with what we're frequently met with on a summary judgment motion, that the plaintiff has not had the opportunity to complete his discovery. We allowed that to be done. We took our discovery, going in part to the matter of the knowledge of the defendant with respect to the plaintiff with respect to the elements of this cause of action, but in general covering the whole case. When that discovery was completed, we within days filed our motion for summary judgment on the grounds that had been stated and pending since 1975. Now, I think the one remarkable thing about the argument that's been presented is that there's been no mention of Chapter 11. And Chapter 11 is at the heart of this. The cases Mr. Gottlieb relies on, the 1906 case, High Court in Minnesota, et cetera, are 50, 60-year-old cases, preceded the enactment of the Chandler Act in 1938. There was no Chapter 11. There was no scheme under which a debtor lost its title upon the filing of bankruptcy proceedings, except to a trustee, specifically if a trustee was appointed.
Well, but apart from Stein, what of the High Court authority stands for the proposition?
Well, Lassiter, if the court please. Stephan, if the court please, the Supreme Court of the United States, and this court. Now, those were in fact not Chapter 11 cases, I acknowledge, but they were cases in which, let's go to that in the matter of knowledge as well, and whether that's necessary. There's no question, I think, that this plaintiff had knowledge of all the elements of the causes of action, which basically are.
They dispute that.
Well, you don't have to have a hearing on that, if the court please. The elements of the cause of action are, as they concede was done, or as they allege, at least, was done prior to July 28, 1972, the great day here. What they say is that Marine Midland represented that it would renew these notes. It repeated that representation according to their arguments on the 26th of July. On the 28th of July, Marine Midland declined to renew, set off, took the money in the lockbox, etc. And on that basis, they allege that they were caused to go into bankruptcy. Now, that allegation is contrary to what they said in their affidavits, the bankruptcy proceeding, but never mind. Those are the elements of their cause of action, and it does not, there's no, it's a title, that's all we're talking about, a label of whether you call it fraud or misrepresentation or breach of an implied contract or some kind of equitable cause of action. Everything that was necessary to show that there was a cause of action, in fact, was done by July 28, as Justice Gammerman in detail pointed out, and as the court can do for itself by simply going down the complaint and saying that the fraud cause of action that they assert purportedly separately is no different at all from the other cause of action. Now back to this question of whether you need knowledge.
Ask on that, excuse the interruption.
Yes.
there's no basis then for the allegation that the fraud cause of action arose at a time after the bankruptcy?
No basis, Your Honor. There's no basis, no factual issue there whatsoever.
Not even alleged that it arose at that time?
They allege it, they say it, that's an argument that they are making, but their allegation is based on no fact that was essential to the cause, to the accrual of the cause of action.
All right.
Now on the matter of knowledge or ignorance, because that's fundamental here, I think, because you don't even have to get to the knowledge point. If you look at Lassiter and Stephan, the essence of those cases is not that there was knowledge. It could have been an innocent matter of non-disclosure. The point of the matter is that on the analysis both of the Supreme Court and this Court, and on a proper analysis of the Bankruptcy Act as Stein interpreted it, consistently with Lassiter, the essential point is that the trustee, or in the case of Chapter 11, read debtor in possession, because under Chapter 11, a debtor in possession is a different entity from the debtor who comes in. And Mr. Gottlieb's reading of Section 342 is simply wrong. It says the debtor continues in possession and then speaks of a debtor in possession as an entity. Now that's what's different about Chapter 11. And the debtor in possession specifically takes on all of the title and all of the duties and obligations, responsibilities of a trustee. So he's in the same position as a trustee. Now Lassiter says that under the scheme of the statute, in order for property to revest in the debtor at the conclusion of the proceedings, there has to have been an election made by the trustee, read debtor in possession, by the debtor in possession to abandon the claim. And the Supreme Court says that doctrine can have no application when the trustee is ignorant of the existence of the property and has had no opportunity to make an election. It doesn't matter whether it was innocent or evil. He didn't know. He couldn't make an election. And that's exactly the same thing that this court held in the Stephan case. Here it does not appear that the claim was brought to the attention of the trustee or that any such election was made by him. Therefore, it cannot be said that the trustee elected not to accept the claim and suit. Now, I think that's the end of it. I don't think I need to say anything on the lockbox point other than that's supposed to be a cause of action, quote, dealt with in the terms of the Bankruptcy Act. That was a litigation, the Graybar case, that had to do with the title to a check, or the proceeds of a check, for $137,000. It didn't put anybody on notice. It didn't put the debtor in the court on notice, or the creditors on notice in the bankruptcy proceeding that there was any claim there. I'll leave the...
There's a lot of other claims, though, is it not?
I beg your pardon?
Even if we were to accept that contention, there are several other causes of action.
Well, there really are in two categories, if the court please. One is the lockbox situation, in which they claim, well, that ought to stay anyway, because that's a matter of a cause of action having been dealt with in the bankruptcy proceedings. Well, it wasn't dealt with because it's a wholly different thing. Now, the other causes of action that we're talking about here are really all essentially the same cause of action. They're the wrongful seizure, they're fraud, they're negligent misrepresentation. But when you read them all, they're all asking for precisely the same damages. They are all said to have caused the bankruptcy. They are all based on the same essential facts alleged through the complaint, paragraphs 1 through 37, essentially. There's no difference among them. And they all are rejectable, should be rejected, on exactly the same grounds, namely that none was disclosed in the bankruptcy proceeding, and under Lassiter and under Stephan and under the scheme of the Bankruptcy Act, that's the end of it. There's no standing in this defendant to assert any of those causes of action.
Thank you very
Thank
much,
you, Your
Mr. Dickey. People versus Julio Marrero. Fine, we only reached the mistake of law issue, is that correct?
Your Honor, I believe that you have the right to reach the first issue for several reasons. Notwithstanding this Court's decision last year in the Corley case, I believe, first of all, this case is factually distinguishable, and second of all, the Court in Corley was not addressed with the claims which we make here.
Well, it's not the same claim, but the same fundamental issue.
The same fundamental issue, Your Honor, but if you look at the briefs in Corley, the briefs in Corley only address the merits, because this Court had dealt with an issue in a similar procedural context in People v. Green. Our office assumed that the Court had the right to reach the issue in Corley, even though there had been a dismissal for failure to prosecute. Accordingly, in our brief, in the Corley case, we never addressed the procedural ramifications of the dismissal for failure to prosecute.
Green was significantly different, is it not?
Green was significantly different, and perhaps we were wrong in relying on Green to believe that there was no procedural obstacle to your hearing the merits on that case. But nevertheless, our office did not argue in our brief in that case, and we do argue in this case, that the only explanation, conceivable explanation, for this attorney's failure to perfect his appeal was one of two things. Either he was constitutionally ineffective in failing to meet his obligations as an officer of the court and as a representative of his client to file a brief, or he failed to file the brief because his client was indigent and could not pay him. Now, we have record evidence in this case that our client was, in fact, indigent throughout the course of his representation by this attorney. This attorney stated on the record at the time of the trial that his client had not paid him since the beginning of his representation, and he begun his representation at the time that he filed the leave application back in 1979 to appeal from the Appellate Division's reversal of Justice Malonis' order dismissing the indictment. He filed the leave application. He then did nothing else for this defendant. He said on the record that his defendant had never paid him money during the course of his representation. He said it in a different context. He said it in the context of whether or not he was required to order minutes of prior proceedings, or whether, because of his client's indigency, the court should provide him with those minutes. And in fact, he said that his client was indigent, but he had never put in for 18B representation, and he had never put in for court costs. And the district attorney justifiably argued that he was not entitled to 18B treatment because he had never put in for 18B treatment. The attorney said, well, that might be so, but in fact, I have never been paid by my client, and my client is indigent.
I'm having difficulty understanding, in light of Corley, what rule do you propose?
The rule that I propose, Your Honor, is that if the record establishes that there was ineffective assistance of counsel for failure to perfect an appeal, or that the only other explanation was that the lawyer failed to perfect the appeal because his client was indigent and could not afford to pay him, that in either event, that defendant is being deprived of his constitutional rights if this court fails to hear the appeal on the merits. Now, in Evans against Lucy, the Supreme Court dealt with a very similar situation in which there was an appeal as of right in a state court in which the attorney failed to comply with the procedural requirements of the state court, and the appeal was therefore dismissed. The Supreme Court ruled that the lawyer's failure to comply with the state's procedural obligations violated the defendant's right to the effective assistance of appellate counsel, and furthermore, that the state court's dismissal of that appeal without providing the defendant a remedy in state court violated his due process rights. Now, in this case, we're not dealing with an appeal as of right. We're dealing with an appeal by permission. But we contend that the circumstances in this case are indistinguishable from those in Evans, because although this was not an appeal as of right originally, once leave had been granted, and leave was granted by the dissenting justice in the appellate division, once leave was granted, the defendant had an absolute right to have his appeal heard by this court. And having had that absolute right, if his lawyer forfeits his obligation to represent the client and forfeits his obligation to file the brief within the period of time required by this court's rules, and as a result of his unconscionable neglect, the case is dismissed for failure to prosecute, the lawyer might be penalized for this failure to comply with the court's rules. The client cannot.
Isn't it so, Mr. Fine, that for all we know, even if we accept your premise that he has an absolute right for the appeal to be heard, that it may have been an instance where the litigant decided to forego the appeal? We don't know that because you're asking us to look behind the order to the reasons for which it was dismissed.
Except, Your Honor, we know that there was no motion ever made to withdraw the appeal, and any lawyer acting in good faith, if his client told him he no longer wanted to perfect the appeal, would not simply allow the appeal to lapse and have this court dismiss it for failure to prosecute. He would file a motion in this court to withdraw the appeal on the grounds that his client never wished to pursue it. There was no motion filed in this case to that effect. Therefore, we can presume, I think, in the absence of such a motion, that there was no direction on the part of the defendant to abandon this appeal. But in fact, the record also shows that the defendant in this case was present throughout the proceedings, was employed, and at the time of the sentencing, the judge said that he had expressed an interest throughout the beginning of this proceeding to clear his name. There would have been no conceivable reason for the defendant to have instructed his attorney to abandon the appeal in this court. And in fact, there's no record evidence that he did so, and the record evidence is that his attorney never filed a motion in this court to have the appeal dismissed or to withdraw the appeal on the grounds that his lawyer, that he no longer wanted the appeal to be perfected.
How could we assume indigency given that reason?
Your Honor, I believe that on the record, the attorney states unequivocally that he was not paid throughout the course of his representation by the defendant. I think that establishes the defendant's indigency.
Because you don't pay a lawyer?
Your Honor, if the defendant is unable to pay a lawyer, and the attorney in this case never claimed that his failure to pay him was due to any unconscionable withdrawal of his responsibilities in this case or anything other than neglect. And as a matter of fact, Your Honor, the lawyer asked for 18B treatment at that point. And having asked the court for 18B treatment, I think you can presume that the lawyer did not get paid because his client was indigent. Because if it had been a case of his client just simply failing to pay him and failing to meet the obligations of his representation, he would not have asked for 18B treatment. He asked for 18B treatment because his client was indigent. That is the only explanation on this record for the attorneys not having been paid. And so although you do not have definitive record evidence in this case that the lawyer either failed to file the brief because of his ineffectiveness or failed to file the brief based on his client's poverty, we do have a record which excludes all other possibilities. And this court has a long tradition of recognizing that an indigent's appeal cannot be denied on the grounds of his indigency, and that a client's right to appeal cannot be denied based upon his attorney's unconscionable neglect in perfecting the appeal. I believe the record excludes all constitutionally permissible alternatives to this lawyer's neglect, and that the only remaining explanations are impermissible under the Constitution.
But those arguments are premised on two assumptions. Those legal principles and that argument are premised on two assumptions: indigency and non-abandonment of the appeal.
That's right, Your Honor. We believe that indigency is established by the lawyer's statement on the record that his client never paid him in his application for 18B treatment.
You do concede that's not the same. Non-payment is not the same as indigency.
I agree, but when you have a statement on the record where the lawyer applied for 18B treatment, I think that you can say that the only explanation for non-payment under those circumstances is indigency, because otherwise the client wouldn't be entitled to 18B treatment. We have indigency established by the record. Abandonment of the appeal we can't establish, except by saying that if there had been abandonment of the appeal, a lawyer meeting his professional obligations would not simply have allowed the appeal to lapse, but would have filed a motion to withdraw the appeal. No such motion was filed in this court. Therefore, I think that the only two remaining explanations are, number one, the lawyer never met his professional obligations, failed to comply with the rules of this court, and therefore violated the defendant's right to the effective assistance of appellate counsel, or else the lawyer never failed to file the brief, forfeiting his own professional responsibility to file the brief because his client couldn't afford to pay him. Since the record excludes all other alternatives, I believe that the appeal should be heard. Furthermore, Your Honor, and in the Corley case, as I said, these issues were never raised, and this court has made it clear that it does not decide issues which are never raised before it. One of the arguments which could have been made in Corley for hearing the appeal is that this court stated in People v. Blake in 1974 that the doctrine of law of the case should very rarely, if ever, be applied against defendants in criminal cases, and that even under circumstances in which that doctrine might otherwise be applicable, if a manifest injustice would occur by applying the law of the case doctrine, de novo review is required. I believe in this case a manifest injustice has occurred throughout the entire pendency of these proceedings. This defendant was arrested 9 years ago under the honest...
Just ask,
Yes.
okay, a question. Does Corley affect both your points or just the
No, Your Honor, it just affects the first point. I do have a problem here because I requested 20 minutes of argument, and I believe that it will be absolutely impossible for me to argue both points within those 20 minutes, and I'd appreciate the Court's indulgence in permitting me to argue both issues and answer the Court's questions if it has those questions. Corley only affects the first argument. But on the merits, Your Honor, I believe that this case also presents the most fundamental of claims. Corley only involved the claim of a deprivation of a right of confrontation, an important claim to be sure, a constitutional claim to be sure. But this claim involves a claim that the defendant is totally exempt from prosecution, that he's not a criminal, that in fact he shouldn't...
Excuse me, I don't want you to use up all your time without addressing the issue with respect to the mistake of law and the failure to, or the preclusion on the part of the trial court.
Okay, Your
Speaking
Honor.
for myself alone.
Okay, Your
I
Honor,
find that one of the most
I'll then
compelling
address the
arguments
mistake
you
of
have.
law issue now, and if you'll indulge me, then I'll go back and address the merits of point one. On the
If
mistake...
you have any time left.
Yes. On the mistake of law issue, Your Honor, there has been an old rule that's gone back to the days of the Romans, that ignorance of the law is no excuse. That rule has been subject to considerable controversy. It has been assailed by numerous commentators. There are other commentators who believe that at least vestiges of it should be retained. But that common law tradition, that common law history is really no longer relevant in this court, because there is now a statute which the New York legislature passed when they enacted the penal law in 1965. Under that statute, I believe it quite clearly, under its express terms, provided for a defense under the precise circumstances present in this case. The New York mistake of law statute, which is penal law section 15.20 subdivision 2, states that if a person mistakenly believes that his conduct is non-criminal, he has a defense if that belief is based on, quote, an official statement of the law contained in a statute or other enactment. Now, my client testified that he had studied the exemption provision of the penal law, exempting people from weapons possession if they were peace officers, and the cross-referenced peace officer section, specifically the portion that stated that a person is a peace officer if he is an attendant, official, or guard of any state prison or of any penal correctional institution, and that he honestly and in good faith came to the belief from reading those statutes and from studying their provisions in a criminology course which he took at Hostos Institute. He was advised by members of the New York City Police Department, which is relevant under subdivision D of the mistake of law statute, that in fact he was a non-criminal. But in essence, he formed the belief based upon those statutes that he was exempt from prosecution. I believe that under the clear, unequivocal language of the mistake of law statute, he has a defense. Now, my adversary has argued that notwithstanding the language of the statute, that your mistaken belief may be based upon, quote, a statute. My adversary argues that a mistaken belief can only be based upon a statute, but if that belief as to what the defendant thought the statute meant was correct. In other words, according to my adversary, you have a mistake of law defense only if you're not mistaken as to the law. Now, that would obviously render that statute a nullity. My adversary also suggests that this court apply the limitation on the mistake of law defense contained in the Model Penal Code. The Model Penal Code would only provide a defense under these circumstances if a statute upon which the defendant relies is afterward declared erroneous or unconstitutional.
Thank you very much, Mr. Klein.
Okay, I would just like to point out, Your Honor, that as I stated in my reply
Your
brief...
time is up, Mr. Klein.
Okay, Your Honor. Thank you very much.
Mr. Machidi, what about that argument? It seems to make a great deal of sense. When would you apply a mistake of law defense?
Your Honor, you would apply a mistake of law defense in a situation where a statute perhaps has been held unconstitutional, and a defendant can show that he relied upon a statute and when he performed his conduct, and therefore he has a defense of mistake of law.
Is that the only time?
That's an example of a statute.
What is the best case you have for that?
Well, there are no cases construing this. There are some very old cases. I have not cited them in my brief, and I'm reluctant to go into them now because it isn't fair to counsel to do that. But there are old cases construing mistake of law as to statutes in that way. Usually it comes up when a statute is declared unconstitutional after the fact of the conduct.
Then Mr. Klein correctly represented that the only time you feel the defense of mistake in law relying on a statute is applicable is when the statute is unlawful.
When the statute is unlawful, when the statute has a mistake in it, there's a possibility the statute can be mistaken, can have an error in it. In that case, you
The
rely
statute can-
upon,
excuse
they
me.
have an error in it, in its wording. I suppose that's a situation where a defendant may rely upon that error and do an act, and he may then rely upon that as a mistake of law defense, because he relied upon that statute.
Suppose in addition to the statute, you had an appellate division decision that held the other way.
That's,
And the second department chose to disagree with that. Came down as they did here, 3 and 2. Would that make any difference?
well, that would seem to me to fall into the third category of the 1520 exceptions, that is a judicial decision, where, for example, a lower court may erroneously decide something, and a defendant may rely upon that decision and do an act that is later found to be illegal, because the decision he relied upon was erroneous, was later overturned. That, again, is a mistake of law defense. Just as an opinion under subsection D, an interpretation by the police department official, or interpretation by some other official or the Attorney General's office, perhaps, if it's erroneous and it's relied upon by a defendant in a personal letter or something like that,
The
would be a
statute
defense.
plus a decision going that way is enough. The statute alone, even though whether it applies or not is problematical, is not enough.
Well, no, I think each of these would be sufficient, but each of these are separate categories. A statute may be unconstitutional, may be mistaken for that reason. A judicial decision by a lower court may be mistaken and be erroneous. And
That's
relied
only,
upon.
that's it. In other words, if you look at a statute, and it could mean something, there's some degree of ambiguity there, and the defendant reads it that way, and indeed, 2 judges of the appellate division read it that way, nevertheless, you don't think that the person can use that as some kind of justification for violating this very ambiguous law?
Absolutely not, Your Honor. If in fact the law is ambiguous, legally ambiguous, then he has a remedy. The remedy is that the statute is ambiguous and therefore it falls for that reason.
I
It is
see,
not.
but that has to be a judicial determination. The
That would be a-
ambiguity has to be adjudicated in ambiguity, not the kind of ambiguity which you or I could read and say, gee, that's close.
No, Your Honor, because the reason for this is because if it were a personal interpretation of a defendant, his personal reading of a statute, the defense would be so wide and so broad that it would encompass so many cases it would be impossible and unwieldy to deal with.
Well, then, Mr. Rossetti, then let me pursue that, if I may, with you. Are you arguing then that the narrow construction and interpretation is based on the wording of the mistake statute or the purpose of the mistake statute, which you see as a narrow exemption from criminal responsibility?
Your Honor, the answer is both. The wording itself gives you a very clear indication that it's meant to be construed very, very narrowly. First of all, it starts out by saying a person is not relieved of criminal liability for conduct unless this mistaken belief is founded upon an official statement of the following. Now, there's no use in that statute of the word reasonable belief or good faith or other things that would trigger that you're looking into the mental process of the defendant. It's just founded upon an official statement contained in these several categories. The idea is clear that what they're addressing is mistakes in these several categories, mistaken statute or mistaken interpretation. If they meant to talk about the defendant's own interpretation, his own personal view of it, they would have had some indication indicating that his mens rea is somehow involved in this, and there is none here. And it's clear that they didn't intend that. No other jurisdiction, by the way, has ever held that. My opponent...
Fact finder couldn't make that determination and say whether or not it considered or the jury considered that to be a mistake of law.
Well, I'm not sure that it couldn't make that determination, but I said that under the statute it's not permitted. I was saying that the statute that is not a defense. I'm sure that many defendants would love to be able to say that I misread the very complicated drug statute and I thought I could do certain things because it is complicated. There are lots of sections and lots of cross-referencing. If that were the case, every complex statute would be amenable to this mistake of law defense, and that's far too broad a reading. No other jurisdiction...
Well, in many cases, there would be no reasonable ground for believing that the defendant really relied on it or thought it.
Well,
in cases absent some decision saying that the statute means what the defendant says he thinks it means, if there's a showing that indeed he did rely, and there is a real basis in the statute for his belief, shouldn't there be a question of fact on it anyway?
If, Your Honor, it does fall into one of these categories, you're right. It has to be an affirmative statement of some kind, containing a statute or decision of some kind. It is not subject to...
Here you've got a statute.
We do have a statute, and that was at the time of trial.
The only thing you don't have is some decision saying that the statute means what he says it means.
That's right, and if we had that, Your Honor, he certainly would be entitled to say he relied upon that, if of course he could show that he actually relied upon it, and use that as a defense. However, there is no such thing in this case. At the time of trial, as a matter of fact, it was already determined that he did not, that the statute was clear, and therefore it was not submitted to the jury for that reason, and for the reason that he had no basis. He could point to no statute, he could point to no interpretation under subsection D that would give him a mistake of law defense. And Justice Hornblass correctly determined that there was no jury issue here on the question of mistake of law. There is a dearth of authority in terms of case law, and it's hard, neither side has pointed to very much, but I would say that, again, no jurisdiction has gone so far as to say a defendant's personal interpretation of a statute, a mistaken interpretation, provides him with the defense of mistake of law. And I think that would totally eliminate any sense that ignorance of the law is no defense. As to the Corley issue, if I might, we don't know very much about. Much is unknown about why no brief was filed in this original case in 1980. But certain things should be kept in mind and are known. The defendant was not incarcerated; he was free and out. He was employed. He was represented by retained, unappointed counsel. He had, at trial, he had the same counsel represent him. This is after the dismissal, and that counsel vigorously represented him at the trial. And I think as you read the transcript in this case, you'll see how vigorous that representation is. All that flies in the face of the speculation that counsel decided he wasn't going to pursue this appeal because he wasn't paid. And I see that my light is on.
Thank you very much, Mr. Seeley. People versus Stephen Miner.
Ready for what, please?
May it please the court, David B. Weisfuse.
Yes,
for
Mr.
the
Weisfuse.
appellant Stephen Miner. One of the most serious things that can occur in a criminal trial is the discharge of a sworn juror over a defendant's objection, since it changes the makeup of the trier of fact.
But there was no genuine objection to Weisfuse. It was almost a matter of an afterthought. In fact, the defendant's counsel had expressly consented when it was.
Well, I think what occurs a lot during a trial might be facial expressions and many things that might not actually appear on the record. What happened in this case is the trial judge seemed to have a reservation and almost like invited an inquiry, invited an objection from the defense. And it was the defendant who had objected to questioning of the juror in front of the other jurors in the case. And what you have here is you have the trial judge making his decision, given his explicit reasons on the record, and the attorney accepted to that decision and those reasons. Now, once the attorney made his exception, the trial judge, knowing that the defendant objected to the discharge of the sworn juror, he had the opportunity to either change his mind, there being an objection, or having a further inquiry of the juror, knowing that the attorney had disagreed with his position in the case. And I also submit to the court that there being the objection and being the reasons given by the trial judge, this issue is preserved, and especially under the amendment to CPL section 47005, where in the legislative history that even if there is a general objection or incorrect objection, as long as the judge decided the issue and the issue is on the record and his reasons, that those reasons are appealable, are a matter for the appeal. And I submit that there was an insufficient basis for this judge, for the judge's finding that this juror would be pressured to render his decision. All I submit that the juror had said is that this would be a hardship. The juror was not specifically asked as to whether he himself would disobey his duty as a juror and rush to judgment and not decide this case based fairly on the merits between the parties. And the courts have been consistent in finding that unless there is obvious or clear evidence that this juror could not be a fair and impartial juror and perform his function, that he should not be discharged, especially when the record is insufficient. And it almost put the onus on the trial court, which wants to discharge a sworn juror, of showing that this juror would be either grossly unqualified or any of the other categories under the statute.
Mr. Weisfuss, are you suggesting that it's an error as a matter of law, or that there was an exercise of discretion here that may not be reviewable in this court?
No, I'm saying there was an error as a matter of law because there is nothing, all merely that this juror has said is that this would be a hardship to him. And a trial judge can excuse a juror based upon a prospective juror based upon a hardship. He cannot excuse a sworn juror based upon a hardship. This juror not wanting to miss his night school class is no different than, say, another person who didn't want to, say, miss seeing his child in a school play, or another juror who wanted to attend an important business meeting.
Well, he indicated he was going to miss his last class. If they had gone further and suggested that if he missed the last class, he was going to fail his course, or that he was going to get thrown out of school, are you suggesting that on that basis there would have been a better basis to exercise the discretion to excuse?
If there was a record where this juror could not fairly sit and decide this case, that it was a very extreme situation, but you do not have that in the record. And once
Isn't that within a range of discretion?
I submit no, Your Honor, because the statute, by having grossly unqualified, I submit that the discretion is to be exercised where you have. Why would the legislature put these higher requirements for sworn jurors as compared to prospective jurors? Grossly unqualified, substantial misconduct, and he was not otherwise unavailable. He was there. I think unless you have like an unforeseen situation like a death in a member of a family or somebody had to be hospitalized, the legislature and the judiciary law has required that jurors serve unless discharged or excused, and prohibits employers from penalizing people because of jury duty. And in response to Your Honor's question about the class, I would say the same philosophy behind that section of judiciary law would apply in the situation of the student.
Are you arguing that there must be some demonstrated consequence in terms of the fairness of the trial, the juror's ability to serve as a result of the circumstances?
Yes, yes. And all this juror said...
Would you say that absent any such demonstration, it's there as a matter of...
As a matter of law, yes. Because otherwise, I think there are important policy considerations. Not only is a defendant prejudiced because he is entitled to a particular jury once the jury is a sworn juror, and whatever intangible and tangible factors, there are many in the selection of the jurors. If a defendant prefers a particular juror over another juror, he is prejudiced because that juror could have been his advocate in the jury room. And there is also important policy considerations to the administration of criminal justice. If you're going to allow the discharge of a juror on this sparse record, the statements of the juror, you're going to lose jurors like flies, especially in long trials, and the standard is the same whether alternates are available or not, which could result in many mistrials.
Weisfuss, I don't want to
Okay.
deter you
or
distract you, but the other argument you have with respect
Right.
to the entrapment defense and the distortion of your defense.
Yes. When you have paid police informants, you have where they depend on their contingency fee arrangements with the police. You have a substantial potential for entrapment of defendants by informants. But how is a defendant going to prove this when he's not allowed to testify as to the statements of the informant for its entrapment defense and is denied a missing witness charge?
Did you ever make an offer of proof on that?
No, there was no explicit offer of proof as to the testimony, but what you have is better than an offer of proof in the record in this case. You have the stricken answers of the defendant, plus you have the procedure adopted by the trial judge when at the end of the colloquy at both 147 and 151 of our appendix, he says, I will decide this issue as we go along. And what happens...
Excuse me, I think the import of Judge Simon's question, and one that I would ask as well, is the preservation aspect. Without an offer of proof or what it is that you were seeking to elicit through your client, where was your timely protest?
The timely protest, there's a protest again at the end of the defendant's testimony where the defense attorney again accepted to the court not allowing him to ask these questions.
But for what purpose?
Seem valid. Most of the objections in the record appear valid. Without an offer of proof, you don't know exactly what you're driving at, what you're trying to get at there.
Okay. Well, the testimony that's in the record is the defendant's testimony that it was the informant's idea to go to the basement where the drugs were taken out, where the informant put the drugs in the dollar bill. And this answer was stricken from the evidence. So that's right. In other words, in terms of an offer of proof, you have the actual, the defendant gave the answers to the questions.
Mr. Rogers, let me
Sure.
rephrase the question. On pages 183 or 184 of the transcript, thereabout, there's a dialogue with respect to this proof and the objection and the colloquy between counsel and the court. Is there anything beyond that where the attorney attempts to show the prejudice of the court's ruling in not allowing this testimony?
Well, this is before the defendant testified,
Yes.
Your Honor is referring. He is saying that it's relevant to the inducement. In other words, the attorney did not state what the actual testimony will be during
And why it is that it was important to his defense of entrapment.
Well, in the opening statement, he said that the defendant was lured by the offer of money, and he was in desperate financial circumstances. He had worked at Peachtree's restaurant with the informant, and the defendant was laid off from his job.
Well, the court said he would allow the statements in to show the defendant's state of mind. Was that sufficient for your purposes?
Sure, that's what the defendant wanted for the inducement prong of the entrapment defense, for the defendant's state of mind as to why he did the drug sales.
Well, the judge said he would allow it in for that purpose, didn't he?
But then the defense attorney asked the questions, and they were objected to, and either the answers were stricken or the questions the defendant was not allowed to answer.
And you say that those questions were asked to elicit the state of the defendant's mind?
Yes, yes. As to
Upon what ground?
Excuse
Were
me.
they stricken as hearsay or stricken as irrelevant? Or both?
I submit that they were stricken as hearsay. All the colloquy, the discussion is as to hearsay in the colloquy section before the defendant testified, and I submit that they were very relevant to the defendant's entrapment defense, especially the questions that this whole thing was the informant's idea for him to go into the basement where the matter concerning the drug sale was discussed. It was the informant who put the drugs in the dollar bill, and it was the informant who told the defendant to give that dollar bill with the drugs in it to the undercover agent, which was stricken from the evidence. And it was the informant to explain why the defendant went to this other location to get the drugs. It was the informant who told the defendant to go see his nephew, Stevie Washington, as this was important to show that the informant supplied the drugs for the drug sale. And I submit that you have that record, which is better with those answers, and you have the questions where it's apparent from the question that the informant had offered the defendant money, yet on 2 occasions the defendant is not allowed to testify as to the informant offering him, giving him money to do the drug sales.
Thank you very much, Mr. Weisfield. Mr. Weil? Well, why wouldn't this testimony be relevant to an entrapment defense? You don't have Washington, the undercover there. You want to show what transpired between the two through the mouth of this defendant, so he could show how he was lured into this impossible situation.
First of all, we don't know what the statements themselves are. We have the characterization now being presented on appeal as to what the content of those statements are, and we have conclusions asserted in the course of the argument as to that they are relevant to state of mind.
Well, but Mr. Weil, excuse me, we know what the questions are, though, and I think what the Chief Judge is asking is, once that question is asked and objected to, blocking the line of inquiry by which we may be able to determine what the answer is and whether it's relevant on the state of mind, isn't that a problem in this case?
Well, except for the fact that at the time the trial judge said, I will permit it under a limited instruction that it can be only used for the fact that these questions were asked or statements made for the purpose of affecting the defendant's state of mind, the response of defense counsel indicated that he wanted to utilize it for more than just the subjective prong of entrapment, but also for the objective prong of entrapment to show some type of intentional inducement on the part of this informant,
Well, if he had
acting as a police.
If he had a dual objective in asking the question, if one was objectionable, couldn't that have been taken care of with a curative charge of some kind, so that he could have at least accomplished the one line and pursuit that he was entitled to?
The court offered the curative instruction to the defendant, but it was apparent from the colloquy that the defendant wished more, which I presume, I don't know, but I presume led the court to question whether or not the defendant was seeking to utilize, under the general umbrella of state of mind, evidence that was far more than just for the state of mind. Now, I don't know what those statements that Washington made to Minor were. You can, in a statement, incorporate a lot of assertions of fact. Even he asked me, objection sustained, we do not know what the question posed to Washington was. It could have been a simple question. He asked me to come with him, which would have been admissible, let's say, or it could have been a statement incorporating all sorts of hearsay facts. He asked me to come to show me the drugs that he says he smuggled into this country. I don't know. I don't know what the statements are. The defendant at the time that this issue arose was in a unique position. He was in a unique position to place on the record the substance of those statements, to give both the trial court and any reviewing court an opportunity to review and to decide whether or not these statements were hearsay, whether or not they were relevant, and in the context of an appeal, whether or not they would have had a significant impact upon the outcome, because there was a lot of other entrapment evidence that he was permitted to testify to. He was permitted to testify to his financial state. He was permitted to testify to the place where he obtained the drugs and from whom. He was permitted to testify as to Washington's role in the situation and the fact that Washington had brought him into this crime. Without that, we're sort of left at loose ends. I don't know what those statements were. The trial judge tried to elicit this from counsel. Specific questions, and they're quoted in our brief, were posed. How, and they were on hearsay grounds and on relevance grounds, how will this show the inducement? How will this show that this was a police agent acting to intentionally induce your client? I'm not quoting him exactly. The quotations are in our brief. And the response from defense counsel was almost, they just do. I mean, they do. It was reiteration of the legal doctrine and nothing specific as to the contents of the statements. Now, I would submit that under these circumstances where we're dealing with extrajudicial statements, where there's a serious question as to their hearsay, non-hearsay character, whether or not they were part hearsay, part non-hearsay, that it was that included hearsay facts which should not have been permitted, a question of whether or not they were relevant to the issue of entrapment, the only issue upon which they were offered, that when the question is posed, the defendant has an obligation, if it's not in the formal context of an offer of proof, but has an obligation to create a record so that any reviewing court and the trial court has an intelligent way to assess whether or not this was admissible evidence. And if the defense counsel does not, and it was his client, it is therefore not improper for the court to take that as a demonstration that there can be no demonstration, and to assume from that he can't make this showing, and therefore to sustain the objections that are made to extrajudicial statements. Now, I would also as I pointed out, there was a lot of the entrapment defense. It was on three prongs. It was the prong of supposedly the informant supplied the drugs, the financial hardship of the defendant, and the informant initiated the whole transaction. There was a lot of testimony as to as to these things. This was before the jury. The statements were, while the statements were not permitted, a lot of the conduct, where they went, where they had gone together, where the drugs had come from. And there was also opportunities for the defendant to elicit other things which would have enhanced a legitimate entrapment claim, such as the defendant claims the source of the drugs is important, and he cites People v. Simone, an Appellate Division 2nd Department case. Simone is a case where the police supplied to the informant the drugs which the informant then gave to the defendant, who sold them back to police. No avenue of what the police role in the informant's conduct here. There was no effort at all made to try to elicit this type of information. I would submit, and I discuss it in our brief, everything that an informant does is not police conduct. Everything that he does is not necessarily within the agency, the scope of his agency. An informant can go into business for himself, can work both sides of the street, and if he does, this is not governmental conduct. Many times, the governmental acquiescence can occur because of the fact that there is lax control upon an informant, and you had the police officers who dealt with the informant before you. There was an opportunity to question them as to what kind of instructions they'd given, et cetera, and no effort was made along those lines as well, a fact which should be considered as well.
Thank you very much, Mr. Wall.
Thank you.
County of Nassau against Cuomo. Catterson.
Good afternoon, Your Honor. My name is James Catterson, and I'm appearing as special counsel for Nassau County, the appellant in this case. May it please the court. The case before Your Honors this afternoon is a classic case, I would believe, for this court to grapple with, and that is the interpretation of not one but two state statutes, generally as to their interpretation and specifically as to the facts in this particular case. Without